he was aiming to kill me. Those shots were intended.
Okay.
My husband was my nurse at home, taking care, cleaning my wound. And at some point when, I'm holding him out, I realized that's a heart level.
That was Molly Darnell, a teacher who was shot at Oxford High School in 2021.
Today was the first day of testimony in the involuntary manslaughter trial of James Crumbley, his son convicted of killing 4 people and injuring 7 others in that mass shooting.
CBS News Detroit's Andres Gutierrez joins us live from the Oakland County Courthouse in Pontiac with details from today's testimony.
Yeah, Shayna, this afternoon, the jury got to hear that frantic 911 call that James Crumbley made on the day of the shooting to report a missing gun and his concerns about his son's whereabouts. It's a gun that Crumbley bought days before the shooting. And during opening statements, Assistant Prosecutor Mark Keese said that Crumbley was grossly negligent because he purchased that weapon and failed to secure it, even though he knew his son's mental health was in a downward spiral. However, Crumbley's attorney said his client had no idea that teen had gained access to the weapon and didn't believe there was an imminent threat. The first witness, as you heard there at the top of the show, was Molly Darnell, a teacher who survived the shooting and described to the jury the chilling moments when she locked eyes with the shooter as he raised his guns toward her. Despite being shot in the arm, Darnell managed to barricade herself and apply a makeshift tourniquet. She later realized the shooter's intent to kill her, as evidenced by the bullet holes in her door. We then heard from a forensic analyst who extracted all the data from all the phones belonging to the Crumbley family and pieced together the surveillance video of the shooting. He also shared some graphic and emotional testimony. Take a listen.
When Tate here just comes in and unknowing to him, he had no idea what was happening. The shooter leveled the gun, and just as Tate turned the corner, the shooter fired around. Tate fell instantly. The shooter took a couple steps and then leveled the gun again, and just to shoot Tate again, laying there, shot him. And you see Tate's body flinch.
Incredibly gut-wrenching to listen to that testimony once again. He ended up tearing up as he gave it to that. There were the parents of Justin Schilling and the father of Hannah St. Juliana that were in the courtroom listening to this testimony. Court again has wrapped up for the day, and they will resume tomorrow morning at 9 a.m. Reporting live in Pontiac, Andres Gutierrez, CBS News, Detroit.
Andres, we know there was a lot of evidence presented before we got started. What's been excluded so far?
Yeah, so the defense attorneys ended up uncovering a piece of evidence where a psychiatrist had a conversation with the shooter, and at the time the shooter told that psychiatrist that he had essentially lied about reaching out to his parents for that mental help that he needed, but the judge would not allow it because it's part of medical records which are confidential.
All right, Andres Gutierrez live for us in Pontiac. Thank you, Andres. And joining us live in studio tonight are attorneys Rick Convertino as well as Arnold Reed. Thank you both for being here.
Thank you.
So just about a month ago, we were sitting here discussing Jennifer Crumbley's trial. A lot of similarities between the two cases, but some stark differences as well. Arnold, on day one, what stands out to you the most about this trial?
4 things stand out. The prosecution came out strong with the hook, talking about to the jury 32 shots fired in 9 minutes, and the person in the courtroom who is responsible for that is Mr. Crumbley. He started out with also setting the scene, taking us inside of the school, telling us what happened, showing us imagery, diagrams, right? I think they started off very, very strong. He told the jury how preventable it was. He knows as a seasoned prosecutor that the jury is going to grab on to the fact that this could have been easily prevented. He laid out the plethora of chances that Mr. Crumbley had to stop this and said it was easy. He had dozens of chances, but he didn't take one of them. And then he followed it up with Molly Darnell. That was the Waterloo, in my opinion, for the defense at this particular point. The defense has got a lot to overcome. Keep in mind also, there was an objection about a statement coming in. The judge said it could come in, and it's a statement that directly shows that Mr. Crumbley had knowledge. And what is that? Right after this shooting, there's a statement where he says, "Is that my kid? That's got to be my kid." Under 802, the rules of evidence, that comes in because it's what we call an excited utterance. He said it in a heat of passion, so to speak. And the law presumes that when you say something in the heat of passion, it's truthful. And so I think today the prosecution got out on the defense. The defense was smart, though. Unlike we saw in the last trial, the defense has sat there, not asked any needless questions. The defense has not made any needless objections. She knows, hey, I better not say anything, because sometimes sitting there and not saying anything is better than putting your foot in your mouth, which we saw a lot of at the last trial. What do I expect? I expect the prosecution to try to diffuse some of the lead that, or the defense to diffuse some of the lead that the prosecutor has established. That's going to come later on. Her big point that she should be making is none of this evidence shows that my client intended for this to happen or my client knew this was going to happen. That's got to be her battle cry. That's got to be her mantra. I said earlier, if this was a football game, it's the first quarter, prosecution is up by a field goal.
Rick, any major takeaways for you, especially in comparison to what we saw with Jennifer's trial?
Well, I think it started off markedly better for both, for the defense, I should say. There was no nonsense about Taylor Swift or any personal invectives that were raised by the defense attorney about herself and her family, et cetera. So I think the defense in the second case learned from the mistakes of the one in the first. One of the things, though, that they didn't do, which I was curious as to whether they would, was Special Agent Wagowski, who was a special agent with the Secret Service, who was an expert under Rule 702 of the Michigan Rules of Evidence, was there to testify specifically about the removal or extraction of computer data from the cell phone, the Facebook data, and the video cameras. Was simply an expert testimony about the way that they process evidence and take it off of the line in order to get it to be admissible into court. In the first trial, Wagowski was allowed to testify as an expert witness and merged into a fact witness by testifying about the specifics of his interpretation of the video cameras that were downloaded, in particular, into Hallway 200. And so he used his own edification in his testimony was, as we heard Andreas say, that Mr. Tate was walking around the corner, was shot and fell to the ground, and then the shooter, in a cold and calculated manner, went over and shot him again. A powerful, powerful testimony, very figurative testimony. You could see the tableau before your eyes, and so that, I believe, in the first trial was not admissible, and equally not admissible in the second. But there was no objection or motion in limine to prevent that evidence from coming in. So unfortunately for Mr. Crumbley, it came pouring in a very powerful and direct way. I think if this were a football game, we're talking about 21-0 right now.
But still in that first quarter. It is still early.
We're in the first part of the first quarter.
Okay, yeah. Very early. With all that in mind, we always have to come back to what is the jury actually considering? It's not just a question of, is this an amazing father? Do you like this man? What are those elements that the jurors really need to consider?
The jurors are considering, I think, at this particular point, what the father did, what the father didn't do. There was, and that witness that Rick had just talked about, that was a long piece of testimony, wasn't it? And I'm sitting here wondering whether the jurors are getting a little bit lost in the details. It was so detailed. I mean, things about dad wanting to care for a horse. Was the prosecution trying to show that, to say, hey, he was more concerned about his animal than he was his child? So inside of those details, right, I think the prosecution wants the jury to think that this is a cold, callous individual, or at the very least a grossly negligent individual who cared more about his animals and tending to his animals. We heard testimony, in fact, that he was too busy doing DoorDash, right? They're wanting to paint a picture of a man who was disinterested, who checked out on his son, and if he hadn't have done that, then we wouldn't be having this trial today. So I think that they were somewhat effective in doing that today. But the thing about it is, you can't have a witness on the witness stand that long. Here, it was kind of necessary because hopefully in closing argument, he's going to come back and he's going to tie all those loose ends up in a very abbreviated fashion. It was necessary for him to do it today, but the prosecution wants to be careful. Now, the defense, on the other hand, again, I expect we're going to see in the coming days from the defense telling the jury, what does this have to do about the elements of the crime? This is all good cannon fodder, ladies and gentlemen, but what does this do to show that my client intended, was grossly negligent for this incident to happen? So you're going to see more of the same we saw in the first trial, bringing the photos in, the shooting at the gun range, the house in disarray, all to paint a picture of parents who checked out and weren't paying attention at all to their child.
Do you remember, though, to break on your point, you know, you have to make this Kierkegaardian leap of faith here between what they should have, could have, or would have known, and what they ignored, or put their head in the sand. And here you have the defense attorney in her opening statement say that my client did not know, could have not have known, did not know when he purchased the gun 3 days before the homicides that he would have done this. Had no idea that he was a danger to himself or others. But early in the morning, right after they left the school, and the photos came out, or the drawing came out, the math drawing, where it had a detailed drawing of the 9mm, the actual Sig Sauer, and the ammunition, and the words, blood everywhere, I need help. Do you remember when Jennifer went back to work, she suspected that her son may have been involved in this shooting when she was aware of it. And the first thing that James Crumbley did when the public statement came out, emergency at the high school, shooting, he determined that it was his son and called 911 with the devastating tape.
How damaging is that? It doesn't seem like that would be the typical response. Most parents are immediately going to wonder if their child is a victim. Not the perpetrator.
He and Jennifer both suspected that their son, oh my God, that was her comment. That was the 8032 statement, the excited utterance. That was her statement. Oh my God, I think he did it. That's what James came to the conclusion of almost immediately after the system-wide email came out that there was an emergency at the high school. That's what he did. He went home, checked for the gun, called 911, and said, I think my son is the shooter.
That's a very important point that Rick is making, because opening statement is one of the most important parts of a trial. It's where a jury gets to hear what your theories are. I mean, they watch television, they hear this case on the radio, but this is the first time up close and personal that they get to hear what the prosecution is asserting and how the defense is countering. And so I'm saying that in this context. Rick talked about the ruling from the court. I was a bit puzzled, I have to admit, that the defense lawyer would say what she said, but they hadn't got a ruling on that 803 issue yet, Rick. Do you know what I'm saying?
Yes.
Why would you as a defense attorney come out there and make that bold assertion to the jury, right? And then we get a ruling later that the statement, oh, it must be my kid, is coming in. Why would you say to a jury that he knew nothing about this, but it's clearly a legal issue out here looming large that could prove that that's an untrue statement? Now, if I was the prosecution in the fourth quarter, when I'm arguing to the jury, I would blow that statement up that the defense lawyer said and remind the jury that that is simply not true. And how do we know? Play the tape, play his voice.
And here's another interesting thing that I think is similar to the first trial and this second trial, and it's very unusual, is that these very important issues of evidentiary importance were not determined months in advance. So these are critical issues, like Arnold just said. I mean, the admission of a statement under 8032 or excited utterance, whether that's coming into evidence or not, as a defense attorney, I want to know that, you know, well in advance of the first day of trial. I don't want to know that after we have a juror sworn and double jeopardy attaches. I want to know that in advance. So I'm going to file motions to determine that. I'm going to file a motion in the second case to make sure that the witness in the first case who testified about this merger between a fact witness and an expert witness, cannot do that in the second case. So none of that was done. So I think those were missteps that are hurting the defense in this case.
All right, well, the trial picks back up tomorrow, and of course, we will continue following it all day long. Arnold Reed and Rick Convertino,
Thank you.
thanks so much
Thank
for
you
being
so
here.
much.